Is your business growing and you have found that you need some help, some support? Maybe you need help creating content. Maybe you need help marketing your business or with sales. Maybe you have gotten so busy that you are covered up with work and you need help actually delivering the services to your clients. Hi, I'm lawyer Autumn Whitboyd, and in today's video and podcast episode, we are going to be diving into another issue with business mistakes, and that is hiring independent contractors willy-nilly, without a plan, without really knowing what the rules are, without making sure that both your business and the contractor are properly protected. Now, we're not going to be talking about employees today, except very briefly to kind of go over the difference between a contractor and employee, because that's something we get a lot of questions about. So let's dive right in. I want to give my standard disclaimer, which is that I am a lawyer. I am licensed to practice in Tennessee, but I am not your lawyer if you're watching this or listening to the podcast. So please take everything just as information. It is not intended to be legal advice. If you have a specific question for your business, please reach out to a lawyer so you can make sure you get the right advice for your particular situation. All right, so let's dive in. I think that most businesses, maybe when they first start out, don't have a team. Most of us started out as solopreneurs, just kind of figuring it out. Maybe we had a partner or a collaborator, but most of us started just doing everything ourselves. But if your business takes off, which fingers crossed, I'm hoping for you happens quickly, you will find that you need either administrative help, like I mentioned, maybe some marketing help. You'll find out that either there are things you're not good at or that you just don't like doing. If you're like a lot of entrepreneurs that I know, you're probably good at a lot of different things, but you will kind of start to figure out, okay, I'm spending time on, what I call $10 tasks when I really should be spending my time on $100 tasks or $1,000 tasks, or as you get further along, $10,000 tasks. Tasks that have a much bigger return for your business is where you as the owner should be spending your time. So it is a great idea to bring on help. And a lot of us think, okay, I'm not ready for employees. And there are a whole list of legal rules that come with bringing on employees. So a lot of us say, I'm just going to start with a contractor, which is a good idea. I'm not saying that that's wrong, but I want to go through some of the mistakes that I see people make when they are bringing on their first contractor or maybe their fifth contractor, and they've just never kind of been taught what the right way to do it is. So when you're figuring out whether someone should be a contractor or an employee, I think a lot of us think, well, if it's someone new, I can just bring them on as a contractor. Or if it's someone on a trial basis, I can bring them on as a contractor. That is not correct. So every state, and I'm an American lawyer, so this is all based on United States law, but every state has its own set of rules and regulations around working with employees and working with contractors. And when I talk about a contractor, I mean someone who is not on your payroll, who you are issuing a 1099 to. Sometimes I hear these called 1099 employees. They're not an employee at all. They are an independent contractor. This is not someone you issue a W-2 to. This is someone, for tax purposes, you issue a 1099 to. So again, there are two levels to this. There are federal laws for employment and working with contractors, and then there are state laws. For most of what we're talking about today, the really important laws are going to be the state laws. So whenever you're thinking of bringing on, and I'll use the kind of generic term worker as I'm talking through this, because a worker could be an employee or a contractor, and we've got to start with this analysis to figure out which bucket they should land in. So your state laws are going to be important when you're figuring out how to classify a worker. You have to look at a couple states. If the worker is not in the same state as your business is located, you need to look at both the law in the state where your business is located and the state where the worker is located, because you really should be complying with both sets of rules. And this doesn't have to be a long, drawn out analysis. Certainly, if your business is making six figures, or if you are beyond that, if you are in year maybe 2 or 3 of your business, yes, this is something that you should probably sit down with an attorney to go over in more detail. But if you're just getting started, maybe this is the very first person you've ever hired. I always talk about how your risk is proportional to the size of business that you have. So if you're just starting out, you're pretty low risk. And, and what I mean by that is the risk that something could go wrong is pretty low. And so I think that your investment in legal services should also be kind of proportional to your risk. So I'm going to talk about some things in a little bit that I do think everyone should be doing. But as far as hiring an attorney to work one-on-one on researching these laws, making sure you're complying, I don't think you need to do that necessarily from day one. Now, should you be spending some time doing a little Google research, which is frankly where we start a lot of the time? Yes, it is not like you can just ignore these state laws. You should definitely do some checking. Both your state where your business is located, again, and the state where the worker is located. Now, unfortunately, for a lot of us who have businesses that work with people all over the place, this is a lot of research. And I wish that we could make it easier by just having the same rules everywhere, but unfortunately we don't. That's just the world we live in. It is state by state. So that's something to keep in mind as you're hiring workers, hiring contractors, or hiring employees. The more states that you have people in, the more kind of burden you have of making sure you're ticking all the right boxes, registering with all the right agencies, complying with all the right rules. But here are just some general overviews, some general things to keep in mind. If you are hiring someone else who actually has their own company, so they have an LLC or a corporation, and they work with lots of different clients, that looks like it's appropriate for an independent contractor classification. So here, for example, we recently redid our website at the AWB firm. If you haven't been there, you can click on the link below, go check it out, awbfirm.com. It's beautiful. That is not something that is part of our services as a law firm. So we hired another company who does provide website services, Launch Party with Shelly. And that is a perfect example of something that is appropriate to hire a contractor to do. We hired a company. She works with lots of other businesses. She actually does have a corporate entity. That looks like a contractor relationship. If you're hiring someone for a discrete project, that also looks like it's appropriate for a contractor relationship. Again, I'll use our website as the example. That was not an ongoing, I need website support every single week and we've got tons of things that we're updating and I need her working all the time. Think about if you're hiring someone for a discrete project that has a start and an end. Like I hired her for a new website and we knew when we were finished and we knew it was going to take about 2 to 3 months. That again, just makes it look more like that's something that's appropriate to hire an independent contractor for. If you are hiring someone for more of an ongoing assistance to your business, so a lot of people start out, their first hire is a virtual assistant. So that's someone that may be in your business every single day for a couple hours a day or a couple hours a week or a couple hours a month. But it's someone who's providing ongoing support to you and your business. If you are hiring someone like that, or maybe someone who's actually providing services to your clients. So let's say you are a graphic designer and you need to hire a junior designer to help you, or you need to hire a copywriter, and they're going to work on all of your client projects. They're going to work with you on a regular basis. It's not just that you bring them on for one discrete thing. Like you got this one client that needs this weird service that you don't normally do. And so you bring someone in for that. This is like an ongoing relationship. That starts to get a little bit more tricky. And that's where I want you to do some research and do some analysis. So the key factor, there are a couple different tests, and we'll include a link in the show notes to this. We have a checklist for comparing whether someone should be an employee or a contractor. So you can go to the show notes page for this episode, which is awbfirm.com/podcast143. If you're watching the video, it's right below there. And you can get our checklist for free. So I'm not going to dive too deep into that because it's long. So you can download that, peruse it at your leisure. But the key thing for all of the tests is how much control do you as the employer have over the employee? And I'll give you a couple examples. So are you controlling when they do their work? Are you do you say you have to work from 8 to 10 every day, or you have to work 4 to 10? If you're controlling their hours, if you require them to come into your place of business, again, that's more control. You're requiring them to come to you. If you are giving them very specific instructions, if you're saying not just giving them a project and letting them figure out how to do it, but you say, I want you to send invoices and I want you to use this form and I want you to use this canned response and I want you to do it this way. And, you have all these things that they have to follow. That looks more like an employee than a contractor because you have a lot of control over how they're doing their work. More detailed instructions mean more control. If you are paying them hourly, so that looks more like an employee than a contractor, because with contractors, we want to incentivize them to find efficiencies. We want, that's how businesses work. We want to incentivize them to make a profit. So if they can get the work done faster, they make more money. Or if they can hire a subcontractor to help them at a lower rate so they can, keep the difference. That looks more like a contractor because they have some financial incentives. If you as the employer are paying their expenses, like if you buy them a computer and you pay for their software, if you pay for their tools that they need to get the work done, that looks more like an employer-employee situation than a contractor. A contractor should really be a business that can do the project on its own. Maybe you reimburse if you have something weird they need, like a very particular software or a particular font or something, or you need to send them to, to one of your facilities to look at something for the project. You can reimburse some expenses. But if you are like sending them for training, that looks more like an employee than a contractor. And then also how you hold out the person. So do they have a business card that has a title on your company's business? Or do they have an email that is, with your domain name, Jane@awbfirm.com. We don't have a Jane. That's not a real address. All of that starts to look more like an employee than a contractor. Contractor usually has their own website or their own way of communicating, their own business cards. And no one factor in all of this is determinative. No, it's not like, if they have an email address, then they're an employee. It's one of those, we're going to look at everything. We're going to balance. We're going to see how it all shakes out because every relationship is a little bit different. So if you want more information about this, I have done a more in-depth podcast on this topic with the AWB firm's employment expert, attorney Michelle Coakley. She works with us on all of our employment matters. She is an employee. That is episode 37, and we'll include a link in the show notes to that episode as well. I will include a note for that. California recently came out with a new law that basically makes it almost impossible to work with contractors if the business is located in California or the contractor is located in California. Our episode does not cover that because it was recorded before that law came out. So just be aware, if you are in California or you have a worker in California, you want to be very careful and make sure you do some research around making sure that you are classifying that person the right way. Okay, so we've gone over just briefly, should you be classifying the person as a contractor at all, or should this person really be an employee? You may want to think about that a little bit more. Why does this matter? Why does it matter if you classify someone wrong? How expensive is that mistake? Well, I will tell you, it can be very expensive. And there's 3 ways that we see this come up most commonly for our clients. There are federal and state wage and hour laws. So this is what we think about with overtime rules. If you work more than 40 hours a week, you have to have overtime. Or maybe some other requirements, minimum wage, those kinds of things. And so what we see is, let's say you have someone working with you, you think they're a contractor, you're paying them as a contractor, maybe a flat fee, or maybe you are paying them hourly, but you're not following all of these, you're not tracking their hours for overtime. You're not making sure that they're making minimum wage, all of those things. Where this typically comes up is after you let them go. And they are maybe disgruntled and they want to kind of stick it to you. And so they make a complaint to the state government or the federal government that you are not following these laws and you owe them back pay. And then you might get audited, and that is no fun. It is expensive. You will have to hire a lawyer or someone to help you probably. That's expensive. If you are found to have misclassified them, so if they should have been paid as an employee and you weren't following all of these laws, you will have to pay not only the money you should have paid them, the back wages, but also there can be penalties, there can be interest. It gets very expensive very fast. I mean, we're talking about tens, $20,000s of dollars for one person very easily if you're doing this the wrong way. The other area that we see this come up for our clients is with unemployment claims. So again, you have a worker that you have classified as a contractor. You think they're a contractor. You're paying them like a contractor. Either they quit or you fire them, or maybe the project just ends and they file for unemployment insurance. So that's a state claim. They file with their state for unemployment benefits. That's the money that you get from the state government if you are between jobs. What happens is if you are working with a contractor, you have not been paying unemployment insurance on that person. You only pay unemployment insurance on your employees. And so they will file a claim and the state will not find you. They will say, you're not covered for unemployment insurance. And that also could trigger an audit, trigger an investigation. And just like I talked about, if they find that you were treating the employee the wrong way, classifying them the wrong way, you could have back pay, you could have penalties, you could have interest. It gets very expensive very quickly. And again, that's for even just one person that you're doing this the wrong way for. And then the third area, we actually had this come up for one of our own clients last year, and it was a sticky situation, is if you have a contractor, they are required to pay their own state and federal taxes because contractors are basically like they are a business. So if you have an employee, there are certain federal and state taxes that the employer pays a portion of. You may have heard of FICA taxes. So like we have a team of 6 here at the AWB firm, and I pay a portion of those taxes every pay period. It's taken out of their paycheck or it's taken from me when we run payroll. And that goes to the federal government and the state government. If you're a contractor, you're supposed to be paying those yourself. And you may have heard of what's called self-employment taxes. You may have heard you're supposed to pay these every quarter. Some people call these quarterlies. They're estimated taxes that you are supposed to be paying every quarter. Let's say your contractor just didn't do that, isn't following the rules the right way. They may complain again to the government, and this would go to maybe the IRS or your state revenue department and say, I should have been an employee and the business should have been paying those taxes that I wasn't paying. Again, we're triggering an audit. Now they're going to dig into all of your records. And if you're found out to have done this the wrong way, you could have to pay back taxes. You could have to pay penalties and interest. So that's kind of to play out for you why this matters and what these mistakes look like on a practical level. So here are some general recommendations. If you have already gone through all this analysis that we talked about and you have figured out, yes, I am working with this person as a contractor, I'm doing this the right way, everything is just like it should be, here are some general recommendations. I want you to use a contract with your independent contractors. Now, a lot of independent contractors, especially if you're hiring like an agency or a virtual assistant firm, they may have their own contract that they send to you to sign for their services. And that's fine. You can totally sign theirs. But I want you to listen to all the things that I think should be in that contract and give it a read. Make sure they're all in there. I think a lot of people don't realize that most contracts are negotiable. So if you find that there's something missing that you wish were in their contract, you can just ask for it. You can ask them to add it or you can ask them to change it. If the independent contractor does not have their own agreement, some people when they're just starting out may not, you may want to have your own that you use with all of your contractors. And I do have some clients that, for example, are hiring a lot of graphic designers, videographers, they're just creating a lot of content. So they're working with a lot of contractors and they have kind of they asked us to put together kind of a standard creative services independent contractor agreement because they have the terms they like. So that's something you may want to think about. If you are hiring contractors, a couple times a year, you may want to have a standard version that you use all the time. So that's an option. But here are some things that I want you to think about. Why do we need a contract with our contractors? We don't want any unwelcome surprises. So your contract should protect both sides. It shouldn't be really tilted towards one or the other. It should set your expectations on the front end. So everybody knows what we're going to be doing. Everyone knows about payment terms and all these other things I'm going to talk about. It kind of also forces you to talk about those things. So maybe it hadn't occurred to you to talk about what if I want to fire you or what if you want to quit? What does that look like? It kind of forces you to go through that. Hopefully you'll both read it. You'll both make sure that you are literally on the same page. And one thing I did want to mention, I get this question every now and then. If the contractor sends you an agreement and you also have a standard independent contractor agreement, should you sign both? The answer is no. Pick one. And if you need to change or add an addendum or tweak a little bit of the terms to make sure that you're both happy with it, that's fine. But you only want one contract. You want all of your terms to be in the same place so that if you have to look back at it later, It's very easy to see because usually if you're signing 2 contracts, there will be some terms in there that do not match, that contradict each other. And it's just more work to have 2 contracts, make sure that they're correct. So we want one contract that has everything we need. So here's, I'm going to go through 5 things that I suggest you include in your independent contractor agreements. The first is who's doing what. So what are they going to do? Again, if you're hiring someone without a real clear idea of what they're going to do, you want to think about that. The second thing is when they'll get paid. So what are you paying them? How are you paying them? Are you paying them weekly, monthly? Is it a flat fee? Is it hourly? Do they have to submit their hours to you and then you pay them? How does that work? Are they, giving you 20 hours and you're paying for that, but if they go over, you pay a little extra? All kinds of payment terms, we want that to be in our agreement, so it's very clear. How you can fire them or how they can quit. This is really important because for good reasons or bad reasons, you may decide you're not a good fit. They may get another opportunity or have a personal health crisis or, who knows? There's all kinds of reasons people decide to stop working together or need to stop working together. So you want to just make it clear, how are you going to wrap up your work together? Or do you require any kind of notice before they can quit? Are you going to pay them for the whole period? Or are you going to kind of prorate it if they quit in the middle of a month or something? You just want to think through that. Another thing that's really important, if you're working with contractors who also have other clients, which they should, if they're a true contractor, you should not be their only client. Confidentiality, and sometimes it's called an NDA, non-disclosure term. I want you to think about that because they may be working for one of your competitors. And you may have things that you don't want them to share, or you don't want them to take you're kind of pulling back the curtain when you're working with a contractor. You're letting them into your business. You're showing them kind of a lot of your secret sauce. So you want some terms in there that go around, can they use, let's say you've got proprietary processes or worksheets or things that you use with your clients that really make your business work well. Can they take those? Can they use them with another client or probably not? Non-compete. This is something I get a question about a lot. So if you are working with a true contractor, if you've classified them the right way, then they should really have other clients. So if you want them to have a non-compete with you where they're not allowed to work for your competitors, or just not allowed to have other clients at all, that starts to make it look more like an employee relationship because that's an area where you have more control over them. So if you are thinking about a non-compete, I highly recommend that you work with an attorney. There are some states, California is one of them, where non-competes are pretty much not enforceable anyway. So you want to be careful around that. You want to be really thoughtful and make sure you're researching it. What may be allowed is what we call a non-solicitation. So that sometimes means like they can't try and steal your employees or steal your vendors or your customers. But that's a little different from a non-compete. Another thing to think about is you could have a really narrow non-compete, maybe where they can't work with someone else in your industry. So let's say you're a weight loss coach. They can't work with another weight loss coach, but they can work with a business coach or someone who sells digital templates or, someone totally different, someone who runs a staffing agency. So maybe you just say you don't want them to work for a competitor. That may, again, we want to research the state law on this. So that may or may not be okay. But think carefully about whether you want to include a non-compete. And I see Linda in the comments when I'm doing this live. She mentions the template pack that she purchased from us. We do have an independent contractor agreement template that's available on our website. Again, if you go to the link below, awbfirm.com, you can get our independent contractor template. It's going to include all of these things that we have been talking about and more. And that's a very easy way to make sure you've got all your bases covered. You're not having to write this from scratch. The last thing I want to mention is you want to include language in your agreement about who owns the copyrights and trademarks and other intellectual property in the work the independent contractor is doing for you. So oftentimes, especially if you are hiring someone to shoot videos for you or to create a sales funnel or do graphic design or copywriting, all of these creative things that we hire people to do for us, they're creating intellectual property. And unfortunately, under United States laws, the way our laws are set up, an independent contractor owns the rights in whatever they are creating. So even though you have hired them, you are paying them to do it, you've probably given them some direction, maybe you've even collaborated on it. Maybe they're using stuff that you've provided. It doesn't matter. A contractor is going to own all the rights in the things that they're creating. So we want to change that with this contract. There's a couple different ways you can set it up. It's really up to you. But I highly recommend that as a business owner, you want to own the intellectual property in anything that someone's creating for you. Now, if you're hiring someone who's really specialized, like a very fancy photographer, or, someone who's really, really good at, whatever their craft is, that may be a negotiating point. They may want to hold on to the intellectual property and just give you what's called a license or permission to use it in your business. I don't love that, but I do understand there are some circumstances when it could make sense. But so again, this is something you want to talk about with your contractor before you get started. Make sure you know who's going to own the rights. If you're not going to own the rights, are there any limits around how you can use things? I actually hired a photographer when I was first starting my law firm, and it was important to her that she owned the rights, and I was fine with that. These were just kind of promotional images, but she put some pretty firm restrictions on how I could use them. And again, I knew how I wanted to use them, and so we agreed on the restrictions, and it was fine. But you want to make sure that you're being careful about that if you do think, oh, I may want to put this image on my website, or I may want to use it in a book or a video. Just have an idea of how you want to use whatever the contractor is creating and make sure you get the right permissions to do that thing. And to have some leeway later on if you decide to do different things. Again, the default rule is that the contractor owns it, but you can contract around that. So that's why we want to make sure we have an agreement with every contractor who's doing anything creative for you to make sure that you are very clear on the rights. All right, with that, I'm going to wrap this up. Thank you for staying tuned to the end. If you want to get that checklist that we have for whether someone should be classified as an independent contractor or an employee, head on over to our website. The link is in the video. It's awbfirm.com/podcast143. I am on Facebook Live every Thursday at 12 p.m. Eastern Time. So join me, and if you have questions, I can answer them live then. Next week's episode, we are continuing our series in the month of June of business mistakes. So next week, we're going to talk about the mistake of not protecting yourself in case your business messes up and you get sued. So we're going to be talking about liability protection, setting up an LLC or a corporation, insurance, and kind of what you need to be thinking about there. And again, we'll play out, what does that look like if you make that mistake? How expensive is it? So you can make the best decision for you and your business. All right. Hope you guys have a great rest of your week. I will talk to you next time.